All right. Call to order this meeting for the Hinckley Township Board of Zoning Appeals on Wednesday, July 26th at 7:38 p.m. This meeting is being recorded for transcription purposes only, and the written minutes and attachments, if any, will serve as the official record of this meeting. Personal conversations should be saved until after the meeting so that those attending virtually may be able to hear. You want to call the roll for the second hearing?
Calabro.
She has an excused absence.
Who?
Here.
Lesnick.
Here.
Schaefer.
Here.
Rubel. Here. Schrader.
Here.
Romanowski.
Here.
Trustee Augustine and zoning inspector Wilson are in the audience. And
As stated in the first meeting,
Do
we have fill-ins. Josephine is traveling, so she couldn't make it. And Rubel is going to sit out because she had a conflict of interest possibly with the second hearing. So Romanowski is filling in and Tom Schrader is filling in. That way we have a full board.
Chairman, who, just for the record keeping purposes, I just want to state that I'm specifically recusing myself because Mr. Fischer is the president of a homeowners association that I currently represent as legal counsel.
Okay.
Thank you.
All right. The Hinckley Board of Township, the Hinckley Township Board of Zoning Appeals acts within the authority of section 519 of the Ohio Revised Code and exercises its powers as provided under chapter 7 and 13 of the Hinckley Township zoning regulations. All public hearings are open to the public. All persons wishing to testify must do so from the podium, must identify themselves and give their resident address, and must be sworn in. Evidence and testimony must be pertinent to the hearing. It is the chairman's discretion to limit personal comment, personal attacks, opinions, editorializing and or repetitious statements or testimony or evidence previously given. Disruptive persons will lose the right to remain at the hearing. Personal attacks will not be tolerated. We received the application for the was submitted by Marcus Fischer for zoning appeal AP. No, that's it.
Yeah, I get 027.
I put the
0276.
0276.
Oh, these are staples. My bad.
Yeah, I got them in the wrong place. Notice of this application was given to the local newspaper and the application has been available for public review and comment. I will ask the township zoning secretary to read the legal notice.
the Hinckley Township Board of Zoning Appeals will hold two public hearings on Wednesday, July 26, 2023 at 7 p.m. at the administration building located at 1410 Ridge Road, which is on the southwest corner of the intersection of State Routes 3 and 303. Subject of the second hearing is as follows. An application for variance AP 0276 was submitted by applicant Marcus Fischer, property owner of 2010 Mattingly Road, Hinckley, Ohio, permanent parcel number 01603A 19039, requesting a variance to split 20.49 acres into two lots with an existing garage not meeting the minimum side yard setback of 30 feet. Inspection of this property will take place on Saturday, July 22nd, 2023 at 10:30 a.m.
All right.
Zoning reference chapter 6, district regulations, subsection 6R1.4.e of the Hinckley Township zoning regulations.
Have you received any notice or mail or any?
Nothing was received.
we poll the board to see if they've done the site inspection and received the documentation for this hearing.
Who?
Yes, and we did the inspection on Saturday, the 22nd.
So last name,
Yes to both, 22nd on the inspection.
Schaefer,
Yes to both, inspection on the 22nd.
Schrader,
Yes to both 22nd inspection.
Romanowski.
An independent inspection on the 25th, and yes, I have the documentation.
Thank you.
Okay, written communications from persons not present this evening may include communications that are not made by affidavit. Because these communications are made by persons not under oath, they are not accepted by this board. I also note that written communications may include some writings, affidavits by persons that are not present this evening and therefore cannot be subject to cross-examinations. These affidavits therefore will not be given much weight, if any, and we haven't really received any. This board has the power to grant an applicant's request for variance. All testimony must be given from the podium and call Mark's up, I guess. Can you state your name and do you solemnly swear to tell the truth, the whole truth, and nothing but the truth as you shall answer under God?
I do. Marcus Fischer, my residence address is 242 Walden Ridge Drive in Hinckley, Ohio. The property at hand here tonight is 2010 Mattingly Road, Hinckley, Ohio, 44233. I'm requesting a 10.5-foot variance on the side yard setback to enable an existing garage to be maintained as part of a lot split. The garage would count as an accessory building under the zoning code, I believe. I'll just briefly start by, I know that there was a site visit on Saturday. Thank you for those that were able to attend and those that did independent reviews. One of the questions that was brought up was the size of the 2-acre lot, particularly the width of the 2-acre lot. It does meet the 175 front yard setback. But one question that I wanted to investigate further was where it becomes narrower down the sides. You'll have approximately 75 feet of buildable space, and then you'll have your 30 feet of setback on both sides. So I measured my house, and my house, which is a 3,600 square foot house, is 60 foot wide. So I think even if the existing dwelling were ultimately to be removed, this is still very much a buildable lot as proposed here, just as your consideration for the lot size as we move forward. The lots should otherwise be in conformance with the zoning resolution, but for the fact that the existing garage will have to be 19.5 feet off the setback line instead of 30 feet off the side yard setback line. Just briefly, I'll go through what I looked at as the Duncan factors, and then feel free to hopefully jump in at any point if you have any questions or concerns. I looked at, will the property yield a reasonable return, or can there be a beneficial use of the property without the variance? This one's a difficult one for me. Yes and no. This property had 2 homes on the property since at least the 1960s until this year. I'm still paying for 2 properties for tax purposes. This property cannot be returned to that state without this variance. Every property, even a completely unbuildable lot, has some beneficial use to it, and that's why we look at the relative beneficial use. What I would say is that the economic viability or reasonable return is substantially diminished, even relative to the value of the property when purchased by me in December, without the possibility of building a second home on the property. Is the variance substantial? I would say no, the variance is not substantial. No non-conforming lot will be created, and the only variance is a variance for an accessory building. I am unaware of any other less significant variance that would enable me the opportunity to return the property to the status quo at the time of purchase, namely with 2 homes on the property. The most recent accessory building variance that I think has been before your board occurred in 2022. And while I know the facts of every case are very different, that one, I think the variance request that was granted was a 20-foot variance. And so I think there it was also determined to be not a substantial variance when we looked at this. So that was kind of my starting point as to how I'm categorizing these things. Will the essential character of the neighborhood be substantially altered, or will adjoining properties suffer detriment if the variance is granted? No, the essential character of the neighborhood will be largely unchanged. In fact, the only difference to the property that should be visible from the road will be the addition of a second driveway for the first approximately 100 approximately 90 feet from the roadway. The existing driveway is a shared driveway for the first approximately 90 feet, the current driveway. And the remaining existing driveway servicing the rear lot can continue to be serviced through the proposed 18.5 acre lot after the lot split. Additionally, no adjoining property should suffer any detriment if the variance is granted. So to be clear, I'm not requesting a shared driveway situation. We'll split it off. And that's why I'm saying the one noticeable thing from the road you'll see two driveways for that first 90 feet, as opposed to one driveway that then Ys off to create the two driveways. Will the variance adversely affect the delivery of governmental services such as fire and ambulance? I don't see any impact to those agencies. Did the property owner purchase the property with knowledge of the zoning restrictions? Yes, I did. What I was not aware of at the time of purchase was the septic requirements, which makes it impractical to split the lot on the west side of the home because the home is almost right in the middle and I have the option to split it to the west or to the east. The problem with the west side is that you have a septic system that runs through there. And given the soil testing, that's really where the septic site has to be. So we moved it to the east side to accommodate the septic on the west side. Can the problem be solved by some manner other than granting a variance? I would say no to this one. The problem could potentially be solved by the destruction of the garage. However, the destruction of the garage would impose a different hardship on me. And it is believed that even if the garage were destroyed to enable the lot split to take place without a variance, it's still likely that a variance would be needed in the future to rebuild a reasonably sized garage because of the distance between that garage and then the home. So if you shifted over the garage, you then run into a variance potential issue because you've got to be 15 feet away from the house for a detached building. Does the variance preserve the spirit and intent of the zoning requirement, and will substantial justice be done by granting the variance? I would say yes to this. According to section 6R1.1, the purposes of the single family residential district are as follows. The R1 district is established to enable the development of low-density, single-family residential dwellings on subdivided lots with a minimum lot size of 2 acres that will promote the continuation of the predominantly rural character of the township. The R1 district is also established to provide for the development of conservation development, planned residential developments to maximize conservation of open space in the township. Another goal is to promote the most desirable and beneficial use of the land in conformity with this section. Here, the variance will enable the creation of 2 large acre, and by large acre, I mean 2 acre or more, lots that both conform to the requirements of zoning. As I previously stated, there will be virtually no change to the character of the lot from adjoining properties or from the road. Additionally, from a health, safety, and general welfare perspective, I submit that the 30-foot setback requirement's primary goals are to mitigate fire spread to adjoining properties and to minimize noises being heard by adjoining properties. If the proposed variance is granted, given that the setback is approximate the narrow portion, the 55-foot portion of the flag lot, there will be no possible change that would increase the chances of fire spread to adjoining properties or increase noise pollution to adjacent properties. The building configuration in the area would remain exactly as is. So that's my submission to the board for consideration. If you have any questions, happy to answer them.
Okay, on the existing garage,
Yes.
if we do grant a variance and for some reason you tear it down and want to build a new one, that variance is null and void. You understand that?
Understood. I've had cost options done both ways on that, and it's actually cheaper to reface that existing garage than it is to rebuild a new garage if I want to pursue a garage while I'm still owner of that property.
What's the main purpose of that barn, just to put it in the record?
The barn or the
Or
garage, the back,
garage that's
For the garage.
the garage.
the main purpose of the garage is a garage for the home on the 2 acre lot.
Okay.
So a traditional garage to park a vehicle. in.
Traditional garage.
Yeah, just detached.
Correct,
Just happens to be detached.
correct.
Anybody else?
Mr. Hoop, you might be referring to the
The
barn.
barn, that's what, yeah.
So the barn is an agricultural exemption barn. It houses the tractors, the ATVs utilized to maintain the woodland management plan to maintain the forestry.
Okay.
At some point, I hope to in the mid to long-term future that will also be taken down. But for now, when this lot split occurs, that will be my only place to store the equipment until a new one's built, which won't happen until I build a home on the property.
The woodland management plan pertains to forestry associated with the 18-acre lot.
Correct, correct. So it's under, so there's an this would qualify for an ag exemption, I believe, and I've submitted the affidavit to the township for that. The property is currently under a CAUV for woodland management, commercial timber. I'm going to continue that. I just revised the woodland, or I just had Legacy Wildlife revise the woodland management plan, and that will be resubmitted to the auditor. I think it's auditor's website. No, it's not. It's the treasurer, I think. Every 10 years, you have to update that plan. And so that plan was just updated. It will be submitted. And so that will stay under that. Agricultural exemption allows for, if you're engaging in agriculture on the property, you can have an agricultural exemption for a building, and that they kind of go hand in hand, but they are two distinct things.
So just out of curiosity, so the large lot will still have more than 10 acres of.
Oh, yes.
Fischer-
Yeah.
Okay.
The 2-acre lot is currently just farmland.
Okay, thank you.
Anything else? I'll check for the audience.
Anybody in the audience have anything or?
Okay, thank you. Very good presentation.
I guess we'll go over the Duncan factors to put them in the record. Ready? Okay. Factor number 1, will the property yield a reasonable return, or can there be a beneficial use of the property without the variance?
Romanowski,
Yes.
Schrader,
No.
Schaefer,
Yes.
Selesnik.
Yes.
Hoop,
Yes. Factor 2, is the variance substantial?
Schrader,
No.
Schaefer,
Yes.
Selesnik,
Oh, yes.
Hoop,
Yes.
Romanowski,
No.
All right. Will the essential character of the neighborhood be substantially altered, or will adjoining property suffer from a substantial detriment if this variance is granted?
Schaefer,
No.
Selesnik.
No.
No.
Romanowski,
No.
Schrader,
No.
Will the variance adversely affect the delivery of government services?
Selesnik.
No.
Hoop,
No.
Romanowski.
No.
Schrader,
No.
Schaefer,
No.
Did the property owner purchase the property with the knowledge of the zoning restriction?
Hoop,
Yes.
Romanowski.
Yes.
Schrader,
Yes.
Schaefer.
Yes.
Selesnik.
Yes.
Can the problem be solved by some manner other than granting a variance?
Romanowski,
No.
Schrader,
No.
Schaefer,
No.
Selesnik.
No.
Hoop,
No. Does the variance preserve the spirit and intent of the zoning requirement, and will substantial justice be done by granting the variance?
Schrader,
Yes.
Schaefer,
Yes.
Selesnik.
Yes.
Hoop,
Yes.
Romanowski.
Yes.
All right, any person adversely affected by a decision of the Board of Zoning Appeals may appeal to the Court of Common Pleas, Medina County, on the grounds that such decision was unreasonable or unlawful. Can we have a motion for a variance?
I make a motion to grant a variance to Marcus Fischer, property owner of 2010 Mattingly Road, Hinckley, Ohio, permanent parcel number 01603A19 039, who is requesting to split a 20.49 acre lot into two lots with an existing garage not meeting the minimum side setback of 30 feet. The lot sizes will be 2.289 acres and 18.201 acres, a rear lot development. The existing garage will be located on the proposed 2.289 acre lot and will be 19.5 feet from the lot line of the 55-foot wide portion of the 18.201 acre proposed parcel. The variance requested is 10.5 feet.
Second, all right. Want to call a roll?
Booth,
Yes.
Selesnik.
Yes.
Schaefer.
Yes.
Schrader.
Yes.
Romanowski.
Yes.
Okay, your motion passed 5-0. Anyone adversely affected by the decision has 30 days from the date in which the minutes of this hearing are approved to file an appeal. Meeting minutes are typically approved at the next regular meeting. Upon approval of this hearing, such minutes will be posted and available on the township website.
Yeah, they got past. Probably. I don't know what happened to it.
Okay.
Oh, there it is.
The wickedness?
It's way back there somehow.
Frank Lancy, 1970 in the back.
All right.
Did I sign it, Julie? Is that a sheet? I don't think it came this way.
I'll make sure you get this. Thank you.
The attendance sheet, did you?
I don't know what I did.
It's like a puddle by.
Hey,
Might have been.
are we good to call it?
Yeah, I guess so.
I make a motion to close the meeting.
So moved.
All in favor, say aye.
Aye.
Meeting adjourned at 8 o'clock on the
Something like
Monday.
this, you know, you go to.